Helen comfortably have 15 minutes to a half hour on this topic, which is essay writing approach for contracts and sales. Organization could be governing law, formation, defenses to formation terms, third parties, performance, and remedies to many calls, which law governs. So there's a breakdown of what goes in each of those sections between the UCC and common law. UCC governs contracts for the sale of goods. Special rules govern transactions between merchants. Any contracts not governed by UCC contracts for service, real estate, construction are governed by common law. How do you form it? And there's offer and acceptance by mutual assent and consideration, bargain for exchange, and promissory estoppel. That's the high level contract issue. I'm just going to look at the low level. Is there a valid offer or manifestation of a present intent contract demonstrated by promise, undertaking, or commitment, definite in certain terms, communicated to an identified offeree? Land requires a description and the price. Goods, the quantity is the most essential term unless it's a requirements or output contract. Other missing terms can be gap filled by the court. And has the offer been terminated? There's lapses of time, revocation, rejection, termination. For lapse of time, must accept within specified time period, or if none, within a reasonable time. Revocation, words or contact of the offerer, terminating the offer, effective when received by offeree, unless the offer is irrevocable. Option contract, offeree gave consideration to hold the open offer. Mutual, what does it say? Merchant's firm offer under the UCC is an exception to that. And detrimental reliance as well. Rejection, words or conduct of the offeree rejecting the offer effective when received by the offerer. Additional terms under common law are rejection and counteroffer, but under UCC 2-207, additional term becomes part of the contract unless one party is not a merchant, the offer is limited to its terms, the other party objects within a reasonable time, and an additional term materially alters the obligation. Termination by operation of law when death or insanity of either party, and that's an offer. That's as it relates to an offer. Destruction of the subject matter of the contract or supervening illegality of the subject matter of the contract. So moving on through acceptance and consideration in the area of formation, common law has a mirror image rule where acceptance of each and every term of the offer is the expectation. Under UCC, acceptance with additional or different terms is valid, but inclusion of terms, the inclusion of those additional or different terms is governed by 2-207 Battle of the Forms. For additional, see above. So we discussed those for different terms. The knockout rule, I think, prohibits different terms from being entered in. And then gap filler terms will be the new terms. I think. Now, so whatever's common in the market. So mode of acceptance, manner authorized by offer, any reasonable manner. And so that's the difference between, I think, common law and UCC is any reasonable manner. Methods of acceptance are special in unilateral contracts where full performance by offeree who knows of the offer is the method of acceptance. In bilateral common law, it's either a promise or beginning performance. However, with UCC, methods of acceptance in bilateral contracts include promise to ship, shipment of goods, shipment of non-conforming goods as acceptance and breach unless it's an accommodation, which is communicated by the merchant. Now, mailbox rule is effective upon dispatch. This is how, under the common law, offers are accepted. In an option contract, the mailbox rule does not apply. The offeree sends a rejection, then the acceptance first received is effective. If the offeree sends acceptance, then rejection, acceptance effective unless rejection is received first and the offerer detrimentally relied. Consideration, must be a bargain for exchange, which is not a gift, and or the detriment to the promisee or legal benefit to the promisor. Courts focus on detriment. Adequacy is generally irrelevant, and there's a lot under the past consideration, generally invalid, quote, pre-existing duty rule. Exceptions to this is a written promise to pay time-barred debt, new or different consideration promise ratifying avoidable obligation, for example, minor ratifying upon reaching the age of majority, compromise of honest dispute, unforeseen circumstance rising to the level of impracticability, good faith modification under Article 2, and substitutes for consideration, promissory estoppel, and detrimental reliance. There must be no defenses. So this is your defenses to formation section. The high-level titles is the statute of fraud, my legs. Certain contracts must be in writing, signed by the party to be changed. My leg stands for marriage, when marriage is consideration as a promise. Year, promises that cannot be performed within 1 year. Land, promises creating interest in land. This also includes leases, easements, fixtures, mineral rights, and mortgages. Executors and administrators, promises to pay estate debts from their own funds, goods over $500, unless they're specially manufactured or the goods are accepted and paid for, or paid for in suretyship, the promise to answer for the debt of another. Is the writing sufficient? Under common law, there's an indication of a contract, essential terms, signed by the party to be charged. Under the UCC, some signed writing indicating contract and specifying quantity. The merchant's confirmatory memo, written confirmation sufficient to bind. One will bind the other if not objected to within 10 days. Does an exception apply? Mistake, unilateral mistake. Contract is voidable if non-mistaken party knew or should have known of the mistake. Mutual mistake. Contract is voidable by adversely affected party if mistake concerns basic assumption on which contract was made. Mistake has material effect and party seeking avoidance does not assume risk. So, reading that again, for unilateral mistake, a contract is voidable if the non-mistaken party knew or should have known of the mistake. The mutual mistake is voidable by the adversely affected party if these three things happen. Mistake concerns a basic assumption under which the contract was made, has a material effect, and the party seeking avoidance did not assume the risk. Fraud and misrepresentation. Ambiguous terms. One party is aware of the ambiguity. A contract is formed. However, if neither party or both parties are aware of the ambiguity, then there's just plain no contract. Now, fraud and misrepresentation includes concealment and non-disclosure. Illegality of consideration of subject matter is also a defense of formation. Same with incapacity, infancy, mental incapacity, intoxication, duress, or undue influence, and unconscionability. The court may refuse to enforce to avoid unfair terms. Example, contracts of adhesion. What are the terms of the contract? So the terms is the next big section of your essay response. Rules of contract construction. General rules of the contracts are construed as a whole. Words are generally given there. Ordinary meaning, written or typed terms prevail over printed. Customer usage in business and locale is considered, as is the cause of dealing. Course of dealing between the parties. The court will try to avoid or find a contract valid, and ambiguities are construed against the contract's preparer. So still under the term section, there's going to be a discussion of modification, parole evidence, and warranties. So modification under the common law, additional consideration is needed. Written contracts can be modified orally, even if there's a contrary provision in the contract. For the UCC, no consideration is needed as long as the modification is in good faith. And the modification does need to be in writing if, as modified, the contract is more than $500 or more and gives effect to provisions prohibiting oral modification. Parole evidence rule, the rule. Prior oral or written or contemporaneous oral expressions are inadmissible to vary, modify, or contradict. So that's prior or contemporaneous expressions are inadmissible to vary, modify, or contradict a contract, and that would be an integrated agreement intended to be the complete and final expression of the parties' agreement. What is integration? Final and complete expression. If it's incomplete, a partial integration, then evidence is admitted to supplement. The merger clause states agreement is complete on its face and is evidence of a full integration. Evidence outside the scope of the rule may be admitted when under the four circumstances listed here: evidence concerning validity, such as formation defects, conditions precedent, evidence used to interpret words, used or uncertain or ambiguous words, evidence showing true consideration paid, and evidence for action for reformation. Like the contract's just inaccurate on something that the parties didn't know about. Warranties, there's title, against infringement, merchantability, fitness, and express warranties. There's an implied warranty of merchantability. Goods are fit for ordinary purpose, implied in every contract by merchant of goods of the kind sold. The implied warranty of fitness for a particular purpose is implied whenever any seller has reason to know a particular purpose for which goods are to be used, and the buyer is relying on the seller's skill and judgment to select the goods, and the buyer does in fact rely. Disclaimers, title, specific language or circumstances putting buyer on notice that seller is not claiming title. Merchantability, specific disclaimer must mention merchantability and in writing must be conspicuous. A specific disclaimer must mention merchantability and if no writing must be conspicuous. Also, can be disclaimed by as is, refusal to examine or course of dealing, fitness for a particular purpose only by conspicuous writing or general disclaimer as is, refusal to examine, course of dealing. Express warranties cannot be disclaimed. And damages is the difference between the goods tendered and as warranted. Has performance been excused or discharged? That's the next large subsection of which there's performance. Will excuse or discharge an absolute duty to act. And in common law, substantial performance is a standard, perfect tender is the standard in UCC. These conditions is the next section. Discharge of duties to unforeseen events such as impossibility, impracticability, and frustration of purpose, followed by or by the parties. And this is actually a uniquely short section. I'm probably going to talk about breach and then skip damages, any parties, and then go into third parties. So let me just finish this section on excusing and discharging. So for conditions, there's two types of types. Express or constructive is the first type, and then precedent, subsequent, or concurrent. After types is the satisfaction of conditions. Express requires literal compliance. Personal satisfaction requires good faith. And constructive, like satisfaction of condition, requires substantial performance. The exclusive conditions, there's like 5 parts here. Anticipatory repudiation is the first part. We'll get into more. B, prospective inability or unwillingness to perform, doubts as to the party's performance, hindrance or failure to cooperate, divisibility of contract, waiver, estoppel, breach of contract, and substantial performance. So under anticipatory repudiation, there's 4 important points. Executory bilateral contract. 2, unequivocal statement of non-performance prior to time performance is due. Non-repudiating party may sue immediately, suspend performance, and sue when performance comes due. Treat repudiation as rescission, urge performance. And 4th, repudiation can be retracted unless accepted or relied on. Discharge of duties by impossibility is an objective test. Impracticability is a subjective test. For impossibility, death or physical incapacity, illegality, or destruction of subject matter are examples. For impracticability, it's an extreme and unreasonable difficulty and or expense, the non-occurrence of which was a basic assumption of the parties. Frustration of purpose, unforeseeable supervening event that destroys the purpose or value of the contract, and The purpose was understood by both parties when the contract was made. By parties, so what is that? A discharge by the parties. Examples: modification of contract, rescission of contract, novation, which is a new contract replacing the parties, releases the original party, and extinguishes the contract. And accord and satisfaction. Accord is agreement to accept a different performance and requires consideration or a bona fide dispute. Second, satisfaction is performance of the accord, discharges accord, and original contract. Have the terms of the contract been breached? There's the common law, material or minor breach. A minor breach, the obligee gains the substantial benefit of bargain, so aggrieved party must perform but right to damages. In a material breach, the obligee does not gain the substantial benefit of bargain, so no duty to perform, immediate right to damages, or other remedies. For the perfect tender rule, if goods or delivery fail to conform to contract in any way, buyer generally may reject all, accept any commercial units, and reject the rest. So that one I'm familiar with. Let's just read material and minor again. Minor breaches, the obligee gains a substantial benefit of the bargain, and the aggrieved party must perform and has a right to damages. For a material breach, the obligee does not gain substantial benefit of the bargain, so no duty for them to perform, and there's an immediate right to damages and other remedies. I'm going to skip damages and other remedies. There's money damages, right? Compensatory, liquidated, cover, land sale contracts, employment contracts, construction contracts, avoidable damages like mitigating damages, restitution and equitable relief. I'm skipping them because there's a whole nother remedies section or body of law we're going to get to. Third party have rights or responsibilities under the contract. Third party beneficiaries include created in a single contract, intended or incidental third party beneficiary only intended have rights under the contract. Vesting of third party's rights, no modification at that point without the third party's consent after the third party right has vested, and they're vested by manifest assent, bringing in a suit to enforce the promise or mutually change position and justifiable reliance. The third party can sue the promisor, and the promisor can raise against the third party any defenses they could raise against the promisee. Also, the third party can sue the promisee if the promisor fails to perform. However, there's two different parts. For the donee beneficiary, they may not sue a promisee unless there's detrimental reliance. For a creditor beneficiary, they may sue on underlying obligation. The creditor beneficiary may sue both the promisor and the promisee, but may obtain only one satisfaction. There's assignment of rights and delegation of duties. These are the last two sections. All contracts, so a transfer of rights under the contract and assignment of rights. All contract rights are assignable unless assignment material alters the obligor's duty or risk, or it is prohibited by law. Contract provisions prohibiting assignment bars only delegation of duties. Revocability assignments for value are irrevocable, which includes a pre-existing debt. Assignors warranty liability to assignee. The assignor impliedly warrants he has made no prior assignment of the right. The right is not subject to limitations or defenses other than those disclosed or apparent, and he will do nothing to defeat or impair the right. Successive assignments of the same right, revocable assignments or subsequent assignee prevails. In an irrevocable assignment, the first assignee has priority. Last section, delegation of duties, transfer of contractual duties. Duties that cannot be delegated are those involving personal judgment or skill, those involving special trust in delegator, doctor, lawyer, those restricted by contract, those the performance of which by a delegate materially changes the obligee's expectancy, and the liability of the parties is the delegator remains liable, the delegate liable if he assumed the duty, and the assignment of contract or rights under the contract construed to include delegation and assumption of duties. So that is going to be it for what I'm going to read right now in the essay outline for contract.